Why is CEQA compliance so hard in California? Imagine trying to build a new shopping mall or a housing complex in California and facing a maze of rules that seem to change just when you think you understand them. That's what makes CEQA compliance such a tricky puzzle here. The California Environmental Quality Act, or CEQA, is designed to protect the environment by making sure projects consider their impact before moving forward. But in California, this law is like a giant web that can trap even the most straightforward projects in a tangle of paperwork and legal challenges. One reason it's so complicated is that CEQA applies only to projects that need approval from public agencies. But what counts as a project or as requiring approval can be very broad. For example, if a city wants to approve a new park or a big apartment complex, they have to do an environmental review. That review can include everything from traffic congestion and noise to air quality and water use. The rules for what needs to be studied are often debated, and agencies have a lot of discretion in how they do these reviews. This means similar projects could face very different requirements depending on who is in charge. Another challenge is the risk of lawsuits. Many groups see CEQA as a tool to delay or block projects they don't like. Sometimes these lawsuits are about environmental concerns, but other times they are driven by neighborhood groups, political motives, or economic interests. A developer might spend years and thousands of dollars trying to get approval, only to face a legal challenge that stalls everything. These legal battles can be unpredictable and costly, making developers wary of moving forward without a lot of legal backup. The process of preparing environmental impact reports, or ERs, is also very detailed. These reports must include data on traffic, noise, pollution, and public health. Gathering all this information takes time and money. Agencies need to hold public hearings and respond to community concerns, which can slow things down even more. Sometimes, agencies overlook impacts or underestimate them, leading to further delays or legal disputes. California has also introduced exemptions and new rules to make CEQA easier for certain projects, especially housing and climate-related initiatives. But figuring out if a project qualifies for these exemptions can be confusing. The rules are constantly changing, and what was exempt yesterday might not be today. This adds another layer of complexity for anyone trying to follow the law. Environmental justice is now a big part of CEQA. Agencies must consider how projects affect disadvantaged communities. While this is a good thing, it means more stakeholders are involved, more analysis is needed, and the process becomes even more complicated. Public health and social equity concerns expand the scope of reviews, making approvals even more challenging. Finally, CEQA lawsuits have strict deadlines. They must be filed within 30 to 35 days after notices are posted. This short window puts pressure on agencies and developers to act fast, but it also makes the legal process more technical and prone to procedural errors. Missing a deadline can mean losing the chance to challenge or defend a project. All these factors combine to make CEQA compliance a uniquely California challenge. It's a law that reflects the state's love for environmental protection and public participation, but it also turns project approval into a complex, sometimes unpredictable process. This mix of legal, environmental, and political layers creates a landscape where even simple projects can become drawn-out battles, making California's environmental laws some of the most intricate in the country.